Welcome to Legal Consolidated. We are drafting today, we're building on our law firm's website, a self-managed super fund, commercial lease. Commercial leases are predominant in Australia and they're under state law. However, a self-managed super fund commercial lease needs to do something quite difficult, and that is comply with the local state laws. So if your commercial properties in New South Wales, it's got to comply with New South Wales rules of tenancy, and it also has to comply with the Commonwealth laws of superannuation. It's a delicate balance, and we'll go through that today. And our self-managed super fund commercial lease complies with both Queensland, South Australia, Western Australia, Northern Territory, ACT, Tasmania. I haven't missed any state or territory out. We're a national Australian law firm. Now, with all our documents, you can see a free sample with a cover letter. You can see a checklist, and you press green button start for free. However, before we do that, I just want to touch on a couple of issues, and that is that there are 7 requirements that you must have in a self-managed super fund commercial lease. It's not a requirement for a commercial lease, but it's a requirement for a self-managed super fund. If you want to know about commercial lease agreements, then there is a separate document you can build on our law firm's website dealing with commercial lease agreements. But today we're building self-managed super fund commercial leases. So there's 7 requirements. The first is that the lease agreement has to look legally binding. So best not to use a template or something fallen off the back of a truck. Best to go to a law firm to draft, such as Legal Consolidated, to build your self-managed super fund commercial lease. It must be an arm's length transaction. You can't do a special deal where you increase the rent in order to inject money into your self-managed super fund. And you can't do the opposite, where the self-managed super fund charges you a lower rent, lower than market rent, basically getting money out of your self-managed super fund. You can't do either. The rent must be market. The whole transaction, everything about the self-managed super fund commercial lease must have an arm's length transaction test. Must be as though you're dealing with a non-related party. The rent must be market. If it's under, you've got problems. If it's over, Professor Davies, what is market rent? Well, I don't know. You'd need to talk to your accountant and your financial advisor as to what, and your real estate agent as to what's fair market rent for that particular property in that time period. The payments have to be clearly stated in the self-managed super fund commercial lease, and they need to, your tenant, which may be a related party, it may be a member, or it may be a independent third party, must pay on time. If they don't, there must be recovery action within the commercial lease for a self-managed super fund, and there must be evidence, a paper trail, and that's why you need a written commercial lease agreement. And finally, the legal side must comply with both Australian superannuation laws and your local state laws. We had a situation recently where an accountant had got a commercial lease. It's a valid commercial lease. It wasn't from Legal Consolidated, but it didn't have all the SIS regulations, and the self-managed super fund was at risk of going non-complying. So a commercial lease agreement itself is not enough. You need a commercial lease that complies also with the SIS legislation. And here it is. We'll be building one of these documents in a minute, but in this instance, the landlord is the trustee of the self-managed super fund, and most of us these days have a company as trustee of our self-managed super fund, and there it is. Landlord, company. As trustee of the trust, yes, it's a double old super fund. The ATO, the Australian Taxation Office, regulates self-managed super funds, and it's important that you comply with the rulings, and our commercial lease for self-managed super fund is compliant with those, but also with all this legislation as well. your self-managed super fund auditor and your accountant will want a physical hard signed copy of the lease agreement. Well, emailed to them, but fully signed. Make sure that's done before the tenant moves in, whether it be a related party tenant or whether it be an arm's length tenant. There needs to be rules for lease disputes, because that's what a usual commercial lease has. So it can't be something friendly. It's got to be a legally binding, hard commercial lease. If there's a dispute, then there's a procedure that needs to be dealt with, which is compliant with the SIS legislation. Subletting rules have to be followed. Fair damage is always a problem, because you don't want to be in breach of your superannuation contribution rules. If a tenant defaults, then what do you do? What if they've added a lot of value to the property? What if they haven't? Let's now look at a situation where a self-managed super fund has borrowed some money. Oh, Professor Davies, self-managed super funds cannot borrow money. You're correct. Self-managed super funds cannot borrow money, but they can borrow money through a gearing strategy with using a bare trust, a limited recourse loan, or custodian trust. Well, in that case, who's the landlord? Is it the trustee of the self-managed super fund, or is it the trustee of the bare trust? Now, you need to speak to your own superannuation lawyer. At Legal Consolidated, we always draft the commercial lease for a self-managed super fund, so the trustee is the trustee of the bare trust, is the trustee of the custodian agreement. I think it's best practice. However, there's got to be a clause in the commercial lease that upon the payments being made and the bare trustee no longer be required because there's now no loan and the property's transferred back to the self-managed super fund, there should be an automatic clause in the self-managed super fund commercial lease, which automatically now makes the self-managed super fund trustee the landlord. That's called an automatic transition clause, and Legal Consolidated commercial leases always have that. Always have that. We've had an auditor speak to us and say that it's a legal requirement to do that. And while Legal Consolidated always has the automatic transition, from what we see, it's not. It pleases the ATO, and it's best practice to have an automatic transition clause in your self-managed commercial lease, but it's not legally required. So here's an example. Kelly Nominees is the trustee, but the property that's being leased is held in a bare trust under a custodian agreement, and the name of that company is 238 Adelaide Terrace. That's the landlord. Once the property has no debt, it's transferred back to Kelly Nominees automatically under a self-managed super fund commercial lease prepared by Legal Consolidated. Automatically the landlord becomes the trustee of the self-managed super fund. There's some examples of how that works. Well, I'm very excited. We are now going to start building for free. Well, the building process is free. Self-managed super fund. So I can pick up data from another document I prepared for my self-managed super fund, but I'm going to start it from scratch. Now, the landlord details could be human, in which case I need to put in those 2 to 6 names, but in my case it's a company. It has to have companies always have 9 digits for Australian company number, and there's its address, and the trustee must be named. What does that mean? Well, the company is trustee of the self-managed super fund, and now we need the name of the self-managed super fund, and that is and the ABN should go in. your self-managed super fund will have an ABN, not the trustee. The trustee of the self-managed super fund would not normally have an Australian business number. It's just self-managed super fund. Telephone the law firm if you need a hand with that. There are no other landlords, it's just that's the only one. And I've got a green tick, which is very good, and I'm going to press next. Now the tenant in this case is going to be Dad John Smith. And the John Smith is not operating through, it's a business, is not operating through a trust. So I don't need to mention the trust there. If he was, if he was trustee of a family trust, we would press yes and put the trustee name there. Guarantors. What's a guarantor? Sometimes the landlord may feel a little bit exposed to the tenant. The tenant may just be a $2 shelf company. The tenant may be a young lad, and we might want a guarantor to go in, being Dad. Now, it needs to be an arm's length transaction. So if it's the case, the tenant lacks some degree of worthiness, credit, then you need to put a guarantor in. Now, in this instance, the father is running running with no assets, so we'll put his wife in as a guarantor. One guarantor will be enough. The premises are and the premises size is 1,400 square meters, and it's going to be run as a butcher shop. My dad was a butcher. The hints on this document, as with all our documents, on the right hand side. So what is the lease date? I don't know the lease date. Well, that hint will help you. What's an option? Again, we will help you with all of that, but the hints, read the hints first. On the date this deed is signed by the landlord and tenant, I'm going to run with yes, when the tenant moves into the premises. When does the lease end? I'll make it 12 months. Would you like to have an option to renew? Yes, the tenant would like that, and I'll have that by 2 years. Could you excuse me for a minute? Now let's look at the option to renew. We've got 2 years, and we'll have 2 plus 1 plus 2 plus 2. And I've got a green tick. I'm very happy with that. What's the rent? Well, I don't know what's current market rent. There's a hint on that. What's CPI? There's a hint on that. So the rent amount per month will be $23,000, and the bond amount will be also $23,000. Would you like a rent review? I think I would. Because the lease is going over a certain period of time, and there could be movement in the marketplace. So I will have a rent review date, and I'll make it current market rent, and that's good enough for me. Outgoings. What's an outgoing? Well, an outgoing is an expense that someone has to pay, like fixing the air conditioning, paying land tax, all those things. Traditionally in a commercial lease, unlike a residential lease or retail shops lease, in a commercial lease, generally the landlord pays for nothing. So with land tax, the land tax might be $40,000. It's paid for by the tenant. So again, you want to be at market here. If you want to do things that are not unusual, so it's usual for the tenant to pay land tax, and you obviously increase the rent accordingly. So water drainage and sewerage tenant, local authority rates. So in the city of Double Bay in Sydney, it's the tenant pays that bill. Land tax, just a disgusting tax. It's so expensive. Interest charge and outstanding rates and taxes. Tenants, water consumed beyond allowance, building insurance. Now, common area lighting, I'm going to put not applicable because it's not a strata property. I could leave tenant in, but I'm going to put not applicable. Security is also not applicable. I'm not involved in the security. If it was a bloody corporate high-rise office block or something, then I may be more involved in that. Would you like to add additional outgoings? And I think I've, as the landlord, have got the what I need. Now, I will call this Smith and Western. I don't need advice. I could always tick the box. And now I'm going to go to summary. And I'm now at the lock and build stage. And that's important because see the green ticks. It means that we, as your lawyer, and we're responsible for this document, we as your lawyer are happy that you followed the logic flow of our document. But now's the time to check the spelling and grammar. So everything looks to be correct. Guarantor, Muriel May Smith. It looks good. Perfect. Tenant pays for all that, not applicable. Done. I'm very happy with that. I'm now going to press lock and build. I will put in my credit card details, my card number and expiry date, and I'll press the pay button. And success. I've built the document. It's been emailed to the address I gave when I logged in, and I can wait for the email of the document. It comes out as a locked PDF, but I'm too excited. I'm going to actually open the document immediately. So I've got lots of different documents. So there it is there at the very top. Now this is a PDF. You can't change this document. It's prepared by a law firm, and the reason you paid us a lot of money is because it's been legally prepared. So if you need to change the document, don't fiddle with the PDF. Firstly, you breach copyright and we'll sue you. No, we probably won't, but you will get into trouble. Secondly, you're not a lawyer, so don't touch the document. And thirdly, you lose the protection afforded by the law firm. There's the letter confirming we were instructed. Goes through a number of conditions. Signed by the law firm. And there's the commercial lease agreement for you. Butcher shop. With all the terms and conditions, everything as required. The document goes on for some pages, and obviously it changes depending how you answer the questions, but it's got to be a legally enforceable agreement. Now, even if you are drafting a lease for a non-related party, so an external person that you've got no relationship with your family, you should still do a commercial lease agreement that's compliant with the SIS regulations, with the superannuation regulations. If you're dealing with a related party like a member or a relative of the member, it's critical that you comply exactly with the drafting of this document. Start building the document for free, read all the free hints, and if you need a hand, telephone us. We're happy to help you build the document. Enjoy.